First of all, thank you very much, everybody, for joining us on a cold Wednesday evening to learn more about the School Inclusion Project and how it will work in practice. I'm Ollie Percy. I'm a barrister at Garden Court Chambers, specialising in public law and education law. We're really delighted to be joined by a group of education practitioners and other experts in the field of pro bono work and community engagement work who will be speaking to us this evening about the various different aspects of the School Inclusion Project and how we facilitate access to justice for children who experience exclusion and a lack of inclusion in the school system. So our running order for this evening will be, first we'll be hearing from Dan Rosenberg, who is a solicitor at Simpson Miller. For anyone who knows the education legal aid sector in any detail, they will know Dan. He's a leading expert in this field, and I'm enjoying him looking painfully awkward at me reading out this embarrassingly not flattering, that would suggest it wasn't deserved, but accurate summary of what he has achieved. He's a tier 1 ranked in Chambers and Partners, and he has particular expertise in exclusions, admissions, and special educational needs. We'll also be hearing from Florence Cole, who is a solicitor at the wonderful Just for Kids Law. And Florence, again, is a powerhouse education solicitor with particular expertise in exclusion issues. We'll also be hearing from Shireen Hassan from Advocate, which was formerly known as the Bar Pro Bono Unit. And Shireen is a senior caseworker. And I was reading Shireen's bio, and the extraordinary amount of brilliant casework that Advocate does in facilitating access to justice and pro bono work by the bar is just extraordinary. In 2020, a record 1,421 cases were placed with volunteer barristers. And Shireen was instrumental in moving Advocate's work online and responding to the change of circumstances from the COVID-19 pandemic. And we're really excited that Advocate will be supporting the School Inclusion Project and will be a forum through which pro bono representation will be facilitated. We'll also be hearing from Jennifer Lewis from the Communities Empowerment Network, one of the project partners for the School Inclusion Project. Jennifer has been CEO of CEN since 2017 and had previously been on CEN's management committee. She has a vast amount of experience. CEN, for those who attended our introduction to the School Inclusion Project, our launch back in the summer, we heard from Gus, who was the founder, Professor Gus John, and CEN is an amazing organisation that works to facilitate representation in school exclusion hearings. And Jen leads the organisation in the development of training, research and campaigning activities, as well as informing and influencing policy discussions. I will shortly be handing over chairing of the Q&A to Michael Etienne, who is an education and public law barrister at Garden Court with me. Michael has a particular expertise in exclusion hearings, and he was one of the nominees for Young Pro Bono Barrister of the Year, partly in recognition of his work representing excluded children through the legal team at Just for Kids Law. And Mike has been a sort of absolutely dedicated and committed advocate for the rights of children facing exclusion. So without further ado, I'm going to hand over to Dan Rosenberg. Thanks very much, Dan.
Thank you very much. What I am going to do is I'm going to do a couple of things. Firstly, I am going to explain about legal aid and legal aid eligibility. And following that, I'm then going to deal with more substantive issues in respect of what are the sort of cases where there may be a legal issue where assistance can be provided, particularly where assistance under the legal aid scheme can be provided. I've tried to do this effectively for a non-legal audience. I think I've managed to avoid any case law, and I've tried to keep it relatively top level, particularly in respect of legal aid. To start off with, on legal aid, there are two types of legal aid. There's legal help, sort of initial advice is another way of looking at it, and legal aid, or public funding certificate, which is more when a case is being taken to court. In terms of who is eligible for legal aid, it can be a bit tricky, and I'm taking a broad brush approach. The initial work, the legal help, it is based on the means of the parents. It is not based on the means of the child, unless they're very, very particular circumstances. Otherwise, effectively, every child in the country, or almost every child in the country, would be eligible for legal aid, which I don't think the government is that keen on. Next slide, please. In terms of financial eligibility, effectively, people need to be on a very low income or means tested benefits, universal credit and so forth. They've got to have low levels of capital, and because it sometimes crop up, there are problems if they own a property. Property in London, Southeast England is going to make them ineligible. Elsewhere, they may be ineligible. There on the slide, which I think will be sent around later, is a government website for people to check. And I've put in a special link there. But if someone working with a family thinks that somebody's likely to be eligible, generally speaking, they are, but get a legal aid provider to check if there are any questions. Next slide, please. So that's the initial side of things. In respect of legal aid certificates, public funding certificates, by this stage, in any event, there'll be a lawyer involved. But there were just a couple of points I wanted to highlight. The first is that in most education-related judicial reviews, the legal action is the child's, so one can look at their means. However, effectively, one is only going to be able to make the applications for public funding once initial work is done, either on a legal help basis or privately, or by a very experienced and legally knowledgeable charity, if there's one involved. The pre-action letters, it can't really be done by individuals or people without the knowledge. It's not going to work. So there are ways of getting parents of low income, but not necessarily, or moderate income, but who are not eligible for legal aid assistance, but one has to somehow get through the initial stage, initial work. The reason that there's non-aggregation is that without it, due to the high cost of judicial reviews and risk of costs, the law would effectively be unenforceable. The legal aid agency sometimes argues this point, but generally they accept it. And there is also public funding certificates available for upper tribunal SEN appeals, and for non-disability related discrimination claims. This is subject to merits and cost issues, and is also for the disability, for the upper tribunal SEN appeals, its parents' names again. Next slide, please. I'm just emphasizing again the way in which legal aid can help non-eligible parents, because I don't think that's fully appreciated. Effectively, judicial review is a very, very powerful and normally very quick remedy, mostly because the matter resolves at the letter before action stage. So it's often worthwhile for a parent who doesn't qualify to instruct a solicitor with a legal aid education contract to advise and do an LBA. And obviously, if a suitable charity is willing to do a good quality LBA for free, that's also positive. There are certain basic cases, particularly around missed deadlines by local authorities in SEN cases, which are quite well suited to charities helping with template LBAs. But mostly solicitor input is going to be required for pretty much everything short of basic missed deadlines. So that's I suppose, the financial eligibility in respect of legal aid and how that works. And I'll take questions at the end. What I'm going to talk now about is the scope of legal aid. The scope of education or legal aid was previously fairly wide, but it was narrowed by LASPO, by the coalition government. So there are nominally 3 areas in scope: special educational needs, discrimination, and judicial review. I'm going to, next slide, please. I'm going to deal with the first of those relatively swiftly and then spend most of my time talking about the third, because it's quite important for people to realise just how wide that is and the sort of issues that can be covered, which are all the sort of issues that the project is looking at. In respect of SEN, effectively anything relating to an EHCP is likely to be within scope for legal help, appeals to the tribunal, refusal to assess appeals, all sorts of appeals, disputes about provision and placement, failure to make provision, failure to admit to a school named in a plan, failure to amend following an annual review. All of these sort of things are going to be within the scope of legal aid. Next slide, please. Discrimination. This is slightly more complex, and I've got a couple of things to say here. Effectively, all school-based discrimination is likely to be within the scope of legal aid. It's important to realise that disability discrimination claims in schools go to the first-tier tribunal. Other protected characteristics, race, etc., they'd be county court claims. And I'm not dealing with any higher or further education issues here because that's not what the project's about. However, it is relatively rare that a discrimination claim or a discrimination angle is the best way to resolve an issue at school. There are a number of reasons as to why this is the case. The primary reason is that there's normally something you can do that's quicker and more effective, particularly if there is the possibility to threaten judicial review, because judicial review has costs, consequences, it's pretty quick, and it generally, a letter for action gets the required result in education cases. There are a number of other issues that can be problematic. A discrimination claim of any sort's often slightly detrimental to ongoing relationships with the school if the pupil is still there. And from a sort of legal aid perspective, there can be difficulties with merits. Damages compared to the cost of the case is sometimes a problem, which lawyers would be able to advise on. And sometimes there are evidential issues as well. What I often find in the work that I do is there's something that feels very much like discrimination to the parent of school, and often is, but proving it is very, very tricky, and quite often one finds a different way of getting the desired result. Having said that, occasionally there will be cases where it is very appropriate to bring a discrimination case, particularly when there's a discrete issue that is in the past, and one is not looking at a forwards-looking remedy. But in all cases where one's considering this, legal advice from people who are very experienced in education law is preferable, mostly to see if there is a better way of approaching the problem. So having dealt with those 2 points, I'm moving on to judicial review. I realise some of this may be basic for some people, but I'm trying to, as I said, gear this towards a non-legal audience. Judicial reviews are challenges to unlawful decisions of public authorities. For our purposes, it's fairly straightforward. Public authority includes all state schools, academies, free schools, they're all state schools, as well as local authorities. There are, interesting legal questions as to exactly how one, the basis on which one judicially reviews academies, but it is not disputed at all that they can be judicially reviewed. It is about wrongs, it is not about rights. And in schools, there is a very wide range of scenarios to which it relates, and the trick is to spot the potential to use the tool. Next slide, please. So, in respect of schools, when can a JR be used? Effectively, any situation where there's been a potentially unlawful decision. There is no judicial review if there's an alternative remedy, particularly an appeals process. And often it's quite hard, even for lawyers, to work out at the outset whether there's a potential unlawful decision which can be challenged. And the other thing that is really, really worth emphasizing to those one is working with is just because a decision's bad or really bad, or the parent or child disagrees with it, it doesn't necessarily mean that it is unlawful. Judicial review is not a challenge to the merits of a decision, it's a challenge to its legality. Next slide, please. All education judicial reviews are potentially in scope of legal aid. Judicial review is an underused remedy in education law. The main reason for this is that there's a lack of knowledge as to the law, that judicial review is a potential remedy, and in particular of the speed and effectiveness of judicial reviews, or effectively the threats of judicial reviews in resolving matters. Next slide, please. In terms of urgency, effectively all education judicial reviews need to be dealt with promptly, mostly because they often involve a child missing education or something going significantly wrong. There's a deadline for bringing a JR promptly and in any event within 3 months. And this is a point I really wish to emphasize, is that complaints procedures are not normally appropriate for forwards-looking issues. I mean, obviously they're appropriate for minor, arguments as to, how a particular French teacher is treating the kid in the class, and matters of that nature. They are not generally appropriate for situations where a child is, for example, unlawfully excluded from school, or not being allowed to continue from, year 10 to year 11, etc. In that case, one effectively needs to move quickly with an immediate JR threat to resolve the matter, mostly because complaints can often take months and months and often are quite unlikely to resolve the issue. And again, lawyers will be able to advise whether something is, suitable for a potential JR. It's the difference between, concerns about what the French teacher is doing and a kid who's not in education at all. And obviously there are, there are things in between. Next slide, please. What I'm going to do now is run through a few areas of education practice, I suppose, and highlight some of the areas where there may be a potential JR and where, potentially it might be worthwhile getting legal input. I'm going to start off with, I've set them out in the slide: SEN, children out of school, alternative provision, admissions, exclusions, off-rolling, progression, that's moving from 1 year to the next, or being allowed to continue with subjects, behaviour policy, and then others. In respect of special educational needs, as I think I mentioned previously, missed deadlines. If a deadline's missed, you can complain as much as you like. If you send a letter before action, they engage automatically, because the alternative for the local authority is that judicial review proceedings are issued and they have to deal with it anyway. And I've set out a number of potential areas, deciding whether or not to conduct an assessment, whether or not to issue a plan. It's all these things that they're deadlines for all of these, and that is just a way of moving things forward. And hopefully, I know that the School Inclusion Project is looking to try and template some of the more basic missed deadline ones. There's also the issue when provision is not made, that is set out in section F of the EHCP. It's obviously very useful here for the EHCP to be for the provision to be very well specified. Otherwise, it makes actually enforcing it very difficult. But that is the way to go forward: a threat of a judicial review under Section 42 of the Children and Families Act. What we quite often see is, people thinking it's discrimination, which it might be, but that's not going to be the way to resolve the matter swiftly. Similarly, people often complain that, X provision is not being made. Again, threat of a JR often speeds things up. And there are other issues related to special educational needs as well. I think I suppose the sort of way to look at it is there a large problem that is stopping something from happening? In that case, it might be worth checking whether there is a potential JR as well as speeding things up. There'll be potential challenges when people move from one authority to another and stuff doesn't happen. All of these sort of issues. I think I'm over halfway there. I'm just halfway there now, so I think I'm doing relatively okay time-wise. In respect of children out of school, something's gone wrong, assuming that the child is out of school because of a reason other than poor decision-making by parents. There's likely to be a solution, and again, judicial reviews of the threat of them is going to hopefully make things move faster. And it's working out which is the best option. There are often a range of options available, and one would want advice on them. So I'm going to go through, just because kids out of school it's the one that really annoys me the most. I get cases coming to me. I think my worst is, I think we've got one 4 years out of school, 3 years out of school. We've had kids out of school for years. And sometimes, we can resolve these things with a letter. And it's just craziness. So yeah, when a kid is out of school, that is particularly when one needs to try and move it quickly, and a potential JR is the way forward. So it might be a threat of judicial review against the school that they were previously going to when they were unlawfully excluded. And I've set out a couple of the, typical sort of phrases used. Can't come back to school, can't attend as your attendance is too low. My favorite, if you return to school, you'll be excluded. The thing to be aware of if one is potentially looking to go against a school is one often needs to give the parents very careful advice, because there has been more than one occasion where I said, okay, we can try and get him back. He has been unlawfully excluded. There is a risk of him getting formally excluded. So, and that risk then comes to pass. So one does need to be a bit alive to these issues, subject to what has happened. But in general terms, you've got to do something to move the matter forward. If you want the kid back and you think that they might be formally excluded, well, you might need to hit the button on a threat of judicial review. They then formally exclude. You've then got your ability to deal with it by the normal process. So that's one potential. I'll come on to refusing to admit in a second. Other issues that arise with children out of school, there's insufficient suitable education being provided to children who are out of school. There's very little education being provided to children out of school, which may be challengeable. And there are obviously all manner of reasons why children can't go to school. Gang-related problems, no school place, health issues, not reasonably practicable, which often arises with children with special educational needs. The key point really is it is likely that something can be done to improve the situation. Next slide, please. In respect of actions against local authority, in addition to the issues that I've mentioned, there's sometimes, particularly if you looked after kids, a failure to direct schools to take pupils. Effectively, the schools look at the kid and say, we don't want this kid. And the local authority's got powers to force the matter, doesn't do anything. I've seen that happen too many times. There's very, very often discrimination on the part of schools when they are not taking kids, but again, judicial review is the way to force it and get the kid back into education quickly. If one wants to think about a discrimination claim afterwards, one can, but one needs to sort the kid's education out quickly. There are also issues where fair access protocols aren't used. Next slide, please. Sorry, it's slide 19. I'm going to do a little bit about alternative provision, just because it comes up relatively often. The issue normally arises where effectively someone's in alternative provision and they're not happy, or their parents aren't happy, particularly when it's going to lead to them not obtaining any meaningful qualifications when they are capable of getting them. For maintained schools, there's quite there's a statutory process and regulations. For academies, it's slightly more freeform, but there's normally something in the funding agreement. Any issue where children are in alternative provision and are not happy, there may be an issue there. Sometimes, there may be nothing that can be done, but it is very often worth looking at. Next slide, please. Admissions. Admissions appeals aren't in scope, and in fact, I was chatting to a dad about this just before I came on this seminar. A classic thing that will happen is that a parent will apply for a school. The school will say no, school will say no, sorry, no places, and will not give a right of appeal. Yeah, that's unlawful, brushing off. They also seek to brush off applications when they do have places and they don't want that particular kid. So there are, and sometimes when they find out, when a place is offered to a kid, they find out a little bit more about them, and then they withdraw the offer. I had one of those a number of years ago, where the 14-year-old dyslexic black kid from had been effectively unlawfully excluded by his previous school. Eventually, a school had agreed to take him. They then, a place was offered. They then had a call with the other school, and then they withdrew that offer. Schools can't withdraw offers of previously offered places. And that seems to come up a fair amount. And it's almost always prejudice or discrimination based, but it can be resolved very swiftly via a judicial review threat. The kid can be got into school very swiftly. Moving on to exclusions. Effectively, if there is a formal exclusion, permanent fixed term with a right of appeal, there is no judicial review, not in scope for legal aid. It used to be within the scope of legal aid. It was taken out of the scope of legal aid by LASBO. However, there will be other aspects that may be within scope for legal aid. Any issues related to special educational needs or potential discrimination, but one couldn't get legal aid for the actual exclusion process. And very often, the fact that the kids have been excluded is an indication that something else might need to be done. When exclusions were within the scope of legal aid, I dealt with many exclusions where the kid would get permanently excluded. I might look at the speech and language therapy report for the child and think, what on earth was going on here? This child certainly, has very serious problems. It's not surprising that they've been struggling. They need an EHCP, and in all likelihood, would be, may well be better placed in a special school. And those things might come up, things that should have been addressed previously, for which there may be legal help available. Next slide, please, 22. Off-rolling. This is, in summary, a child being removed from the school's role for the benefit of the school as opposed to the child. There are many ways in which this happens. There's almost always likely to be a potential judicial review if done, and therefore it's going to be within scope of what one generally needs to move fairly quickly. Arguing for a long time doesn't necessarily help. One needs to move fast. Back to more exclusions and off-rolling. Next slide, please. Obviously, anything that's not a formal exclusion is an unlawful exclusion. But linked to this is various cunning ways in which schools try and get kids to leave, but keep them on the premises. And one way, which I've seen a number of times, is your child will remain in isolation until they agree to leave the school, or until they agree to a managed move. If they don't agree to a managed move, we will exclude them, and so forth. This is all unlawful. Again, when advising parents, one does need to be aware of the risk of permanent exclusions. Then moving on to sorry, if I just keep on the slide, there are potential judicial reviews at the very end of the appeal governing body, then independent review panel. Then there are potential judicial reviews of governing body decisions not to readmit following successful independent review panel appeals. But one obviously needs to think at that stage as to the wisdom of returning to that particular school. Next slide, please, 24. I've got a slide on non-progression. This is effectively anything preventing children from continuing from one year to the next, keeping them down a year, threatening to keep them down a year. Any academic or attendance criteria stopping progression is going to be unlawful. One needs to move extremely fast on these, because often they crop up at the end of the school year, or just at the end of the school year, or the start of a new school year. One has to move very fast, otherwise the kid misses too much of the year. And stopping people taking exams which they've been prepared is also unlawful. Even stopping people continuing with one particular subject, forcing them to change to BTECs, etc., halfway through their A-levels, likely to be unlawful. Anything along these lines, it will be in scope, although it requires a bit of often creative thinking as to how to phrase any challenge. My favorite one of these, well, I just couldn't believe what the school was doing, was a kid who had to look after his disabled parents. He missed huge amounts of school. His attendance was 30-40%. He did show up sometimes, and he was in year 10, and effectively he was given a piece of paper, or his parents were given a piece of paper to sign saying, either I agree to repeat year 10 or I withdraw my child from the school. And we took the case on, and ironically, it turned out that this child was actually, despite having missed most of the year, still on course for extremely good GCSE results. It was just, I suppose, just normal prejudice-based decision making. So anything like that, there's something that can be done, but it's not going to be straightforward, and it's quite tricky. I've got next slide, please. I've got a slide in here about looked after children. If something's not happening in respect of their education, particularly if they're out of school, there's going to be some sort of legal remedy by way of judicial review. I think I've got one section in there. All looked after children are going to be eligible for legal aid. So there will be something that can be done to move matters forward. I've done numerous cases for looked after children effectively getting them into school. I've got just next slide, please. In respect of behaviour policies and use of isolation, obviously these are the cause of many problems in schools, particularly for children with disabilities, neurodisabilities in particular. The behaviour policies, of course, are a matter for schools, and schools are given considerable leeway with them. One thing that is particularly likely to be a problem is repeated and egregious use of isolation. But this is very complex legally. The sort of cases that I've dealt with are generally when children are just being kept day after day in isolation, or large amounts of their time they're in isolation. Just wanted to briefly mention non-attendance prosecutions, school attendance orders. Any of these prosecutions aren't themselves within scope. There are, sometimes there are very helpful criminal solicitors firms, particularly if they've done a number of these cases, who can assist. But there's very often an underlying problem as to why the child is not attending. And that is often capable of being dealt with and remedied via judicial review threat. So I've done numerous cases where parents are being prosecuted or threatened with prosecution, and the way I've gone about dealing with it is by challenging the failure of often the failure of the school or the failure of the local authority to provide suitable education. So just because it's not within the scope doesn't mean that there's not something that can be done. And then I've got a sort of random selection of other issues where there may be something that can be done. Anything relating to police in schools, where often police are causing problems that they shouldn't be, and certainly problems that that their superiors would not be keen, because the last thing the police really want is to annoy a load of children, but sometimes they do so. So there's often stuff that can be done on that point, particularly in respect of public sector equality duties. Anything relating to bullying is generally speaking not in scope. It will to be dealt with via complaints and so forth. However, in some cases, particularly where there's an egregious failure by the school to deal with it and protected characteristics are involved, there may be something that can be done at the very least to get the school to take the matter seriously. I've written a number of letters on behalf of various children of traveller heritage, just to ensure that the school actually engages. Issues related to school transport, potentially there may be something that is within scope, but only if all internal appeals have been exhausted. And there may be various things that lawyers can do when county lines issues are present, which unfortunately is extremely common for kids who are out of school, and particularly if they have special educational needs. And there are no doubt many other situations, issues that didn't immediately spring to mind, where there is something that can be done within the scope of legal aid to try and move matters forwards. So to summarise, there are legal aid is there, it is available. Obviously, numerous parents will qualify, but remember, even if they don't qualify, there may be ways or means of making use of the fact that it's available for children to bring judicial reviews once initial work's been done, to move matters forwards. And there are a very, very wide range of situations where a judicial review can be used as a very effective means of progressing matters. There's obviously other areas, special educational needs and discrimination, where legal aid is also available. But certainly in our experience, a lot of the time people come to us very, very late in the day, after large amounts of school has been missed or things have gone quite badly wrong. The law can, there's lots of very, very good law in respect of education. There's lots of very helpful provision. very helpful legislation, very helpful regulations. You know, one just has to make use of it, and you know, that's what legal aid and lawyers are there for. Thank you very much. I will see if I think there are a couple of questions. I don't know whether people want me to answer them now.
No, we'll save those, I think, Dan, for the Q&A later.
Okay, fine.
Thank you so much for giving us such a comprehensive presentation on the potential benefits of legal aid and actions which may be adjacent to legal aid. You may have noticed that I'm not Oliver Percy. Ollie is currently refining his slides for his presentation coming up shortly about exceptional case funding in the context of exclusions. I am Michael Etienne, a barrister at Garden Court Chambers. I was listening in to the start of the event, so I can give Ollie his £5 for the generous introduction later. In the meantime, we're going to move now to Shirin Hassan, who is a senior caseworker at Advocate, who's going to talk to us about the benefits and her experience of pro bono representation in exclusion hearings. Shirin.
Hi, everyone. Thank you for joining us. I'm just going to pull up our slide, and I'm going to be covering about who we are, what we do, and how we work, and how to make a referral to us. So I'm just going to take us through now. So who are we? So we are Advocate. We were formerly known as the Bar Pro Bono Unit. We have over 4,000 barristers who volunteer with us. And each year we receive 2,000 applications from members of the public covering all areas of law, including education law. What we do is we match barristers with members of the public. Our volunteer barristers provide free legal advice, drafting, and representation. We assist members of the public and small organizations who cannot obtain legal aid or afford a barrister. So those who fall out of scope with legal aid or can't afford legal fees, then they come to us where we can assist. And how we work is we receive an application form, and if we've got all the documents that we require, we send it off to a reviewer, a senior barrister who is specialized in their field, and they make an assessment to see if this case warrants pro bono assistance. Once the decision is back from the reviewer, it's passed back down to the casework team who summarize the case and begin searching for a volunteer barrister to take on the case. A barrister can put in their interest via our website. So it's a bespoke panel member website, so they can log on to there and look for cases, but they're also approached by members of the team on a regular basis. A barrister has around 48 hours to decide whether they can take on the case or not. If they can take on the case, Advocate does slip into the background, and the barrister and applicant liaise with each other moving forward. A checklist for referrers and applicants is this. We need to make sure the applicant is not eligible for legal aid. If they are eligible for legal aid, we will be signposting them onto suitable organizations. We also assess to see if the applicant can pay privately or not. We do require a minimum of 3 weeks notice before any hearing date or deadline. We do have exceptions to this, so we do assess each case on a case-by-case basis. The piece of work will take less than 3 days, so we do ask for the case or the piece of work to be less than 3 working days, because barristers tend to take on cases outside of their working day, and the piece of work is something that a barrister can do. So what can barristers do? They can represent the person in court or in the tribunal. They can give them legal advice, whether it's oral, over Zoom, or in person, or they can write written advice. They can also draft documents. What a barrister can't do is prepare case and the paperwork to go to the court, or anything to do with administrative support or write letters. How to apply. A form is available online and it is downloadable as well. Referrers are encouraged to help applicants complete the form. Applications must include all available case papers listed on the website. Courts which will include court or tribunal papers, including court orders, judgments, and so forth, papers or opinions from solicitors or advice agencies or barristers who have previously been involved in the case, and key correspondence with any other persons involved in the case. For example, the other side, in this example, if it's with a school, or in any correspondence. If you are seeking help with an appeal, a copy of a judgment will be needed. If seeking help about contract or formal documents, a full copy of a contract or document will be required. Contact details. So our preferred method is to email us the application form, but we do understand, as sometimes not everyone is able to complete the online form, although it's very self-explanatory. You can download it and you can send it to us in hard copy. Key questions. So, can an individual apply to advocate directly? Yes, they can. A parent can apply to us directly. However, we do think in some circumstances they would benefit from a referrer to help them put together their documents to ensure everything is included in the chronology of everything. As I said previously, can applications be sent in hard copies? Yes, they can be sent in hard copies, but the team are working remotely, so it may be a bit slower for it to be sent in hard copy. Can an applicant speak to a caseworker directly? They can, but they would need to leave a voicemail on our systems, and a caseworker will be allocated to them and they will give them a call. When will an applicant hear about their case being accepted? Well, it's a bit of a long process. By the time we receive the application and we prepare the case, it can take up to 1 or 2 weeks for us to get in touch with the applicant and to confirm whether the case is being sent to a reviewer. And then once it's with the reviewer, it can take up to 5 working days. This is why we ask for 3 weeks notice before any deadline or hearing. So I've covered everything on my end on how to make a referral to advocate. If you've got any questions in terms of how to make the application or what documents to include, please do email me on shirin@weareadvocate.org.uk. Thank you.
Shirin, thank you so much. And I know that you have to leave us, I think, at 6 o'clock. So thanks very much for joining us so far. From one organisation doing incredible work pro bono to another, we move now to the Community Empowerment Network and Jen Lewis, the Imperious CEO. Jen. You're still on mute, Jen. See what we can do about that.
Sorry about that. Thank you very much, Michael, for your for that introduction. I've been asked to talk about CN's referral process to the SIP, and I'm not giving a presentation. I'm just going to talk that through. We're happy to share our slides, our templates with anyone who would like to share. We don't see ourselves as in competition with other organisations at all. So we're happy to share the process as long as the SIP is happy for us to do that. So CEN has its own internal referral process for when any of our advocates, all of whom are volunteers, feel that they've exhausted all avenues available and the case requires further legal assistance beyond that which CEN is able to offer. This is the point when a referral is made to the School Inclusion Project. As part of CEN's triage process, which takes place during the initial stages of engagement with the client, we seek permission from the client to share details of the case should the case require escalation. However, as part of the referral process, we need to carefully manage the client's expectations, and the advocate managing the case is required to consider and discuss with the client the following. What is the legal basis for the referral, i.e. points of law? What the further impact on the child or the family might be, particularly if this is detrimental? Is it justified by what might be a distressing process which may not better the situation? And might there be a better way of resolving the problem? And thirdly, does the parent qualify for legal aid? This may be the first hurdle at which a case falls. However, as you've just now been introduced to advocate, who, as Shirin, has shared, will accept cases that are not eligible for legal aid. And there's also an alternative route via which the legal aid application may be made in the child's name, which I think Dan alluded to earlier. Each of our CEN advocates has a supervisor who must approve the referral before it's sent to Dushan, who is our operational development manager, with the following documents: a copy of the case log detailing all interactions with the client to date, a case synopsis providing an overview of the case, and the bundle containing all relevant documents pertaining to the case. This may all appear to be quite formulaic, but as a charity, CEN's funding is dependent on us being able to clearly demonstrate evidence of what the assistance is that we've provided. Once collated, the above documents are then sent to Emma at GCC. We also request that the advocate make themselves available to meet with whoever accepts the case via the SIP to discuss the case if required, as there may be nuances about the case which may not be easily shared via the paperwork. Having built the relationship with the client, the CEN advocate maintains a vested interest in the case as well as in the outcome. And hearing from those to whom the case has been referred to is vital to us as an organisation, as it allows us to complete the engagement circle, both in terms of ending the case, as well as allows us to document the assistance that the client has been able to access and whether or not this has been successful. We don't always count success in terms of wins and losses. However, we want to ensure that the process has been successful, i.e. the management of the escalation. So as I said earlier, I'm happy to share both our process and templates for any other organisation to use as a basis for their own process. And I'll ask Amy to share my details with the group.
Jen, thanks so much. Really helpful. Just a reminder, anyone with any questions, either about logistics or slightly more legal, technical questions, do drop them in the Q&A so that we can hopefully between us offer some helpful insights a little bit later. For now, we're going back to the subject of legal aid with Garden Court's resident expert on exceptional case funding, Oliver.
Thanks. I'm not sure resident expert on exceptional case funding is something I ever want on a bio, but thanks for that, Mike. Great. I'm going to be speaking to you about the areas of education law that are not in scope and build upon Dan's presentation. And my presentation is primarily a pitch to people with legal aid contracts to consider doing this. So to apply for exceptional case funding for exclusions work to build an evidence base of its utility. So I'm going to share my screen. And this is intended to be a very much whistle-stop tour through exceptional case funding. If I've whetted your appetite and you're a legal aid provider interested in making exceptional case funding applications, I'm very happy to give you a more detailed training session about the nuts and bolts of what you put in an application form and work with you on drafts. But for now, I just want to explain what the basics of exceptional case funding, or ECF, are. So Dan mentioned that exclusions were taken out of scope for legal aid with LASPO. And Section 10 of LASPO introduced what is thought to be a safety net for areas of law that were taken out of scope. And broadly, the safety net operates to avoid breach or risk of breach of ECHR rights, so European Convention of Human Rights, or retained EU law rights. But the most relevant rights are procedural rights to a fair hearing. Those are normally considered to be Article 6 rights, but in some circumstances, such as immigration, Article 8, the procedural aspect of it, is the way in which you protect the right to a fair hearing. I don't want to get too technical. I just want to whet your appetite about why ECF is important and why we need exclusions back in scope. So how do you establish whether there would be a conventional rights breach. While there's been case law on this, and there's a case called Godanavisian, which I've linked to at the end of my slides, and I'm very sorry to be including case law when Dan did such a good job of not. There are broadly 3 criteria, and it's a holistic way of meeting them. They all need to be established, but if you're a bit weaker on one of the categories, you can make up for it for being stronger in another. So the legal, factual and procedural complexity of the matter. So what I'm talking about here is legal aid for governing body hearings and independent review panel hearings. Now, the factual complexity will vary from case to case. The legal complexity increases, particularly at IRP stage, where the people considering the appeal are meant to be complying and applying public law principles. Judicial review is considered to be a complicated subject. So I think there's a strong argument that you could say this was sufficiently legally complex that a lawyer should be involved. The importance of what is at stake, well, we've heard that from Dan's presentation, and I think it's going to be something that's well known to all of us that work in this field. If a child is taken out of school or their education is disrupted, that has a huge impact on a child's development going forwards. And clearly, the importance of what is at stake test, in my view, at least for a permanent exclusion, is made out for any child, regardless of the facts. The ability of the applicant to represent themselves without legal assistance. And while this is a 3-part test, this is the part of the test that the legal aid agency is most concerned with you meeting. You need to establish that you will not have a fair hearing without having professional representation there funded by legal aid or exceptional case funding because it's an area of legal aid that's out of scope. Now, what do you need to establish to show that the applicant can represent themselves without legal assistance? Well, this is a highly fact-sensitive issue. So if the parent, who would be the relevant client here because they have the appeal right, has a relevant disability. For example, I have been funded by exceptional case funding in special educational needs tribunal hearings to represent deaf families, also to represent parents who have communication issues, etc., which mean that because of their disability, they cannot communicate effectively and adequately represent themselves in the hearing. Language barrier or not having an effective command of English is also often a very common, particularly in the immigration context, but in other contexts too, reason for exceptional case funding being granted. There are a range of other criteria, but I think the most important other 2 to consider in the context of exclusions are, 1, the emotional attachment to the material. And it's well established that if you have a too emotionally intense connection with the material and lack the level of objectivity to be an effective advocate, that is a basis for being granted exceptional case funding. The other basis, which I think is important, is just how overstretched parents are, particularly if they have children with complex needs that are leading and having to deal with the difficulty of the exclusion itself, not just challenging it. So the ability of the parent to actually allocate time in a busy schedule when they're going to be having parenting and caring responsibilities on top of engaging in a legal process is a reason for legal assistance being granted. It's important to note that, as with areas of legal aid that are in scope, exceptional case funding applications must meet the means and merits criteria. So Dan spoke to you about the means test, and we always need to establish that the case is not a hopeless one or has reasonable prospects. That hopefully won't be a problem. So education exceptional case funding is a relatively new area, and Dan's firm is one of the ones that have been leading the way in getting it for special educational needs tribunal appeals. it's never been, as far as I'm aware, been granted for an exclusions case. So it's never been granted for representation in either the GBH or the IRP, the two stages of the appeal process. And the reason for that, I suspect, is paragraph 54 of the Lord Chancellor's guidance. Well, one of the reasons. And that takes the view that Article 6 is not engaged in the process. I think that's wrong. And I think that's eminently challengeable, because the case of Tom Hood was handed down before the Grand Chamber decided a case called Orsis against Croatia, which effectively overturned the European Court of Human Rights case that was being relied upon in Tom Hood. So I think it's one that is a point that can be pushed back upon in applications. So problems with education ECF, there's just a lack of guidance and wrong and unhelpful guidance. And there's a useful Joint Committee of Human Rights report which explains why the legal aid agency's approach to Article 6 is wrong. The other key barriers to getting exceptional case funding are it's incredibly slow. The processing times mean that people will have to act at risk. And the legal aid agency is quite obstructive, to be blunt. It requests documents, it asks further questions. But a key point we want to show for the school inclusion project is it is possible to get it, and that it should be being granted, to build up an evidence base that this area of legal aid should be in scope. And as Dan mentioned, legal aid for exclusions is so important, because if someone comes in for legal advice from a solicitor with experience in education law, they can maybe identify an EHCP issue that's also in play. So it's really vital that it's in scope, and a key way that we're going to establish that exclusion should be brought back into scope is by applying for exceptional case funding and getting it granted, and showing the value that it has in individual cases. And this isn't some far-flung, really overly optimistic plan. There's precedent for this. The Children's Society successfully challenged the lack of legal aid for unaccompanied and separated migrant children. Similar to exclusions, that area of legal aid was taken out of scope with the legal aid cuts that came into force as a result of LASPO. Through making lots of exceptional case funding applications, an evidence base was developed about why legal aid for unaccompanied and separated migrant children was so valuable. That led to a JR being brought by the Children's Society and the government conceding. The Lord Chancellor then exercised his powers and brought that area into scope. So I don't think we should lose hope. So practicalities, how to apply. Non-lawyers can apply through a paper form that's on the Legal Aid Agency's website. Legal aid providers can use CCMS. Because this area is completely out of scope, I don't think it just needs to be education legal aid providers. You need to apply ASAP because of the prompt timescales in which exclusion appeal hearings are heard. But even if it's not granted, if you act at risk, you can have your funding backdated from the point of application. So here are some links to some useful resources. Public Law Project, where I used to work, has lots of useful guides on exceptional case funding generally. The Lord Chancellor's guidance is a really good place to start because you'll need to address the unhelpful guidance. And the case that I cannot pronounce, Gudanavicienne, is worth reading if you have time. But any questions, please do email me. This was my sales pitch for making exceptional case funding applications. And if you're at all interested in doing this work, either as an NGO, supporting law centres, etc., or you're at a legal aid provider, please do get in touch. It would be brilliant if more people were making these applications. But I appreciate that there are constraints on legal aid providers that don't receive grant funding in making these applications. So any NGOs that are interested in particular, please do reach out. I'd be happy to provide training on doing this and support you in making these applications. Thank you very much.
Ollie, thanks so much. That was great. I can only endorse what Ollie was just saying there. We really do need to build up an evidence base, either to show that ECF, essentially that the ECF system isn't working, practically in all the ways that Ollie said. And in reality, we're not going to do that without the evidence. Anyway, I'll save my soapbox for the Q&A later. Until then, we move now to Florence Cole, a member of the legal team at Just for Kids Law, who is going to lift all our moods with some examples of why all this work really can make a difference. Florence.
Thank you, Michael, for that introduction. As Michael said, my name's Florence and I'm a solicitor at Just for Kids Law. I've always worked with young people and very passionate about education. And incidentally, I did a lot of my training at CEN in my very early training days with Jerry German. But I've been asked to talk about, some of the examples in terms of how legal intervention can help. There's so many cases, I could be here all day, but the ones that sort of like stick out to my mind and have always stuck with me is, I think, my first ones when I had 5-year-olds who were being excluded from school, permanently excluded from school. And it's like, well, how can a 5-year-old be excluded? And going to represent this 5-year-old and his mother, obviously, a lot of these children, they are, deemed of having some kind of special need. And I remember going to that hearing, first of all, writing to the school. So for those of you that aren't advocates, and as Dan has said about timing is really important because you really do need to think about, what the urgency is in terms of how slow or how fast you can actually act. And with this particular case, this young child had been permanently excluded, had a meltdown in school. I wrote to the school initially asking them to look at this. So for those of you that are advocates, it can be worth, just writing to the school and seeing if you can even set up a meeting with the school. Because I always say with education law, it can be quite creative as well, thinking outside the box. But they weren't having it. So I went to a hearing and managed to get that child reinstated. But what actually came out of that one was the case that they said that they would never wanted to exclude a 5-year-old again, and that they were actually going to change their policies. And the school was actually under special measures as well. And they had asked for some intervention from me in terms of how they think they could make that better. So that was one example of, legal intervention taking place. Another, a couple of cases, ones that Dan has actually highlighted, is a lot of young people being out of school for whatever reason for long lengths of time. All local authorities have what they call a fair access panel, and they are supposed to look at children who have been out of school for whatever reason. But a lot of the times, some of these children are slipping through the net. And so again, it's always worth, contacting the school. A lot of schools, it's worth bearing in mind that a lot of schools don't actually like to be challenged. They don't actually feel that the parents are going to do anything about it. And so they sort of like, try and palm the parents off with useless excuses. You don't need to bring your child back to school. And really it's to do with their league tables, the child's sitting at home and the parents are sitting at home waiting for education to be sent home. And that's not been happening. So again, it's about sending a letter to the school. What I often find is that normally when they get a solicitor's letter, they normally sort of like jump up and act. So you don't have to go as far as sort of like doing a judicial review. But a lot of the letters before action that I have done is a lot to do with, this child has been out of school and there is a duty to educate. And that's section 19 of the Education Act 1996, where there is a duty to educate. So all children must be able to, sorry, the things are coming up in the chat and I'm getting distracted. I won't look at it. So there is a duty to educate. So the schools have to act promptly. There was another case that I had, a young lad in a Harrow school, and he had been unlawfully excluded in this instance. And the unlawfulness was the fact that he'd been told not to come back to school, but the parent hadn't been given a letter stating the reason he had been excluded. So if you ever come across parents who haven't received a letter explaining the reason for the exclusion, that in itself is unlawful. So I said to the mum, take your son back to school on Monday. Might be up for a bit of a fight, but they haven't given you a letter, so take them back. So he did go back to school, and he and I had to advise her that, you know, that may actually, you know, start the exclusion process. He did go back to the school on that Monday, and they phoned me up, the school phoned me up asking me what's going on here. And they were actually asking me for legal advice, because they didn't have a clue themselves in terms of what they should be doing. So obviously I had to advise them that, look, you need to go and get your own legal advice. But at the moment, you're acting unlawfully by sending this child home without a letter. Another case I've had, which Dan worked on as well, towards the end, was the hair case that I had. And she kept being sent home from school to go and change her hair. This was unlawful, clearly, being sent home during lunch break to change her hair. And as time was going on, she was starting to have sort of like, you know, a bit of identity crisis in terms of, you know, what's going on with her. And in that particular case, I would say it was quite slow, because I was working with her along with advocates. So at Just for Kids Law, we have advocates who do as much as they can, and then if they're coming up against a brick wall, then they will hand the cases over to the lawyer. But what was happening in that case is she initially had an advocate who was helping her, and because at Just for Kids Law we're very child and young person led, so the client, the child is our client, the young person is our client. Obviously the parents will chip in if the child, depending on the child's age, depending on their understanding. But a lot of the time our cases, the majority of our cases, are young person led. So with this particular hair case, the young person was quite, I don't know if it's conscientious or quite cautious about not wanting to rock the boat too much with the school. So we went through the complaints process, but we weren't really getting anywhere with that. They were ignoring us. I was contacting the DFE. The DFE had made an order for the school to reply to certain things, and they just weren't doing it. So in the end, and because at that time we didn't have a public law contract or an education contract, we did have to pass the case over, but we've done a lot of the groundwork. And obviously, you know, she got her results with that. So they are things to look out for. And I also feel that, you know, sometimes you can write quite a strong letter and let them know that you're getting legal involved. And sometimes they will just sit up then, and sometimes, you know, issues are resolved. But again, as I say, it's about being creative and sometimes setting, you know, meetings up with the school. And at the moment, not going into too much detail, Michael and I have got a case going on whereby we've exhausted the governing body stage, we've exhausted the IRP stage, and so we've got permission, and there's a hearing date for next April, but it hasn't been without its challenges. And it's one of the first cases that we're taking at the moment to hopefully, you know, judicial review, but we've been granted permission and we've got a hearing date. But I think, you know, in a nutshell, I think you've got to be very passionate about this work. You've got to be prepared to meet a lot of resistance, but it's always worthwhile, you know, pushing forward with those and getting onto that phone, sending emails, keeping a paper trail of who you speak to, and you know, trying to change the course of action, which is happening with a lot of our young people. At Just for Kids Law as well, we have an exclusions hub, which is hopefully going to be up and running in January. So there's a lot going on there, and we do want, you know, work with CEN and various other organisations, and along with SIP in terms of you know, combating this kind of uphill struggle that's been going on for a long time. I have forwarded the link to Amy for the school exclusions hubs, because there are templates on there that you can use as advocates as well. And at the moment, in terms of referrals, it's just sort of like phoning up at the moment and seeing if we've got the capacity to take on cases. But I hope that's given you a little bit of insight there. And so, yeah, because there's loads and loads of cases I could talk about, but yeah, I'd be taking over if I did. So yeah, thank you.
Florence, thanks so much. Before we move to the Q&A, I have been given the joyful job of dealing with some of the more housekeeping related aspects of the school inclusion project. And it also seems like a good time in the course of our discussion this evening just to kind of draw some of the threads together about how we envisage the project working in practice. So what we envisage is that any number of the organisations who are amongst us this evening will essentially be the ones making referrals to us, particularly via advocate and SEN, particularly if instructing counsel is necessary, because obviously there are certain legal requirements about how counsel get instructed. And so we're also hoping to see some collaboration between those organisations that are able to legally instruct counsel, but also grassroots groups who have concerns and who are actively working in this area, almost on a day-to-day basis. We were aware that when the Google group, the email system, if you like, was set up, there were a couple of emails that came in, essentially with members of the public asking for the project to take on cases. That is obviously not how we would envisage that working in future. So we're hoping, as I say, that queries from members of the public will eventually reach the project through our various partner organisations, because obviously we want to make sure that queries aren't missed and that are being managed in the best possible way. And we're also really keen, we're really conscious that everybody is trying to keep their email traffic down. I, for one, am certainly quite keen to do that. And we can understand why there was some concern when the Google group was first launched about that. But we're hoping now going forwards that we've ironed out some of those teething problems to make sure that it can provide a useful space to make contact and raise issues where absolutely necessary. And as I said a few minutes ago, ultimately our aim is to bring about significant improvements in the law and practice in this area. As Dan was saying earlier, there is a lack of case law on exclusion cases, generally speaking, certainly compared to other aspects of education law. We still only have one reported case, for example, on the legal framework that currently exists for exclusions, which is the case from 2014. So it also predates the most recent version of the statutory guidance. So there's definitely lots of fertile ground there, we think, to explore. Florence has touched on one of her cases, and that's one of two cases that I'm working on that both are Just for Kids that deal with essentially procedural fairness issues, compliance with guidance relating to sexual violence in schools, as well as potential gaps in the school exclusion guidance relating to, for example, how you conduct a proper reconsideration meeting. I'm sure many of you will be familiar with the pattern that where even when you're successful, potentially at the IRP, the decision gets sent back, and then you end up with a decision that's not just the same, but it's taken by the same individuals representing the governing body. And so there are certainly public law issues there. And in lots of other areas. I think one of the challenges is getting schools sometimes to appreciate, and governing bodies and independent review panels, as Ollie was saying, about how complex this area can be. There's statutory guidance from the DfE on a whole range of different subjects that might be relevant in the context of exclusions. And the regulations on exclusions make it clear that that guidance is effectively forms mandatory considerations for everybody who has a decision-making role in exclusions. So we're really hoping that the project, as we've said before, will kind of provide a holistic approach to trying to improve the law and practice in this area at the very least, for all the very good reasons that you've heard already this evening. So we thank all of you for your interest in the project and your commitment to the project so far. And we are all feeling really positive, I think, about the potential for what we might achieve working on this together. Time for Q&A. Thank you to those of you who put questions in the chat. If there are any more questions, please just drop them in. I'll try to keep an eye on the chat, preferably in the Q&A rather than the chat, but I'll try and keep an eye on both as the questions are being asked. I will occasionally abuse chair's privilege to ask questions just because I might be slightly interested in knowing the answers myself, but I'll try not to do that too much. The first question, I think, came in from Eleanor Wright, and it touches on something, Dan, that you were saying earlier about the question is essentially about how JR can be used to challenge the sort of egregious use of isolation within schools. You mentioned in your presentation that it's a legally complex area. We wondered whether you might be able to just elaborate a bit more on how that might work in practice if you wanted to bring a challenge like that.
I think there are a couple of things. One is you need very good facts. You need a very good fact pattern in respect of the individuals who are subject to it. Point two is one has to look at the local at the school or the academy chain's behavior policy. And the problem is that schools have a significant amount of leeway. So when I'm thinking about this, I'm also thinking, is there a procedural way of getting at it? The procedural way, one of the things that's quite egregious about the use of isolation is that it's to some extent equivalent to a fixed term exclusion, but there is no requirement to monitor at present, because the government's, my understanding is looking at revising the guidelines. There's no requirement to monitor it. You can't go to the governing body if you have a certain amount of them. So it's going for the oversight, that side of things, as well as, is it sort of fair and reasonable? So there are various angles, both procedural and substantive, and there's also quite often discrimination-based arguments as well. Schools quite often, are not particularly happy if they are asked for the numbers of kids who've been excluded, the number of those who have who've been put in isolation, the number who have special educational needs, the number who have EHCPs and so forth. So they're public sector equality angles as well. So there are a variety of different angles, but one needs, because of the leeway and behaviour policies, one needs quite good facts.
Mike, you're on mute.
Yeah.
Honestly, I should get sacked. Only from the chair. One of the other points you mentioned, Dan, was that cases often come to you quite late in the day. And I sensed a feeling that you sometimes wish that you could have got hold of cases earlier. And I just wondered whether you and others could maybe give us your take on the point at which you think lawyers can really add value in this process.
I mean, it will depend on the facts. So I'll just take something that came to me today. The kid had effectively went abroad, came back, and appeared to have been removed from the school's role back in the summer term. Couldn't sort it out themselves. That should have come, obviously this person has had no assistance. If that had been with some sort of agency or charity, they should try and sort that. If it's not fixed in a week, that then goes to lawyers. Hopefully the kid is back in education within another week or so. So it's those sort, it's particularly where it's the kids out of school, can be sorted very quickly. If it can't be sorted very quickly, and by very quickly I mean, week or so, then consider referring. For other issues, it might not be quite the same sort of time frame, but it's where people are missing education, or any of the progression type cases that I mentioned. It's sort out quickly. If it's sorted out quickly, that's great. If it's not sorted out quickly, and where there is detriment to letting the situation run, that's when it needs to get referred. If it's some complaint about something, if it's something that's happened in the past where there's no particular urgency going forwards, that's a different matter. And then, by all means, try and sort it out, resolve the complaint and so forth. But it's where someone's missing out on something and it's forwards looking, it needs to be done very quickly.
Florence, did you want to come in on that?
Yeah, just quickly adding to that. So I had a case recently whereby young person's got special needs. He's been at home, he was excluded, but the named school on his education healthcare plan, the school were refusing to take him and saying, oh, they haven't got enough funding, they haven't got the resources, and that they wanted him to be accepted there on a trial period. Well, all of that was a nonsense. And so before even doing a judicial review, I literally got on the phone to them and said, this is wrong within a week. This is wrong. Still ignored. And then I set out to them what I wanted to do. This wasn't even actually doing a JR. This was literally threatening JR by way of an email. And within a week, they had actually admitted him into the school, because they have a duty to admit him into the school. So, that was even before actually writing a PAP. That was just an email and a phone call that did that. So, yeah, as you were saying, Dan, it varies in terms of the urgency of things there.
Great. Jen, I just wondered if you could perhaps give us an insight into how potentially people who don't necessarily practice in this area can actually get up to speed, can become volunteers, can be involved in providing help to people in the course of the exclusion process.
Contact us. We're actually having a volunteer. We're doing a new training session at the end of this month, beginning of next month. We haven't quite nailed down the date yet. I think it is the 27th of November. So we're actually doing a training for our newest cohort of volunteers. Because of COVID, we were doing training once a year, and that was specifically with University of Law students. However, we do train anybody else who also wants to join us as an advocate as well. So I think just because of COVID, we've added training dates, and we've also not just that advocacy training isn't just a one. I think when Ollie perhaps was with us, we used to do one training and then you join us. We now do several different types of training in order to properly prepare people to be advocates. So not only the advocacy training, which is by all accounts brilliant, I've done it myself, but we also deliver training in case management, for example, maintaining the relationship with the client and the advocate, safeguarding, etc. So we do, I think there's about five or six training modules that we deliver now. So if anybody just wants to contact us, there's a link that I can send to Amy and we can give to you, or they can just contact us via our website and complete a form. And join us. It's CEN Live, www.cenlive.org. I think I should know, shouldn't I?
Great.
Sorry.
Thanks, Jen. It's all right. I think our colleague Amy has helpfully put it in the chat, and she might be able to pop it back in the chat for anyone who's missed it. Another legal aid question: can firms with a public law legal aid contract, but not an educational contract, bring education JRs? And specifically against maintained schools?
Yes, they can. The legal aid agency sometimes has caused problems for others in the past, I believe. The thing is, if someone doing effectively, what I'd like to say is, if doing an education case, one needs to be aware of all the other issues around it, particularly STN related, and so that those sort of issues are not missed as well. Those sort of issues would not be within the scope if there was something that needed doing on that. So one needs to sort of, if it's very discreet, fine, but just one needs to have be a little bit more aware about the wider issues.
The next question is, I think effectively, in what circumstances would a refusal to make reasonable adjustments be something that you might want to challenge by way of judicial review? Ollie, I wonder if you might take that one.
Sure. It really is a question of the facts, and it's hard to advise specifically without knowing the facts of a particular case. which is a classic lawyer answer of not wanting to give an answer. But you've got to remember alternative remedies, and a failure to make reasonable adjustments for children in school can potentially be challenged through a disability discrimination claim in the SEND tribunal. So you would need to think carefully about whether there are adequate alternative remedies, and that's going to be a fact-specific question. Potentially, especially if folded in with other public law grounds. For example, if there's a policy in place which is unlawful in other public law ways, and the failure to make reasonable adjustments to the policy is one aspect of a challenge, maybe. But yeah, remember alternative remedies and remember what you want out of the process. It's a fact-specific case. Sometimes urgency means that tribunal won't be appropriate. Sometimes, really.
And just to add to that, sometimes it's not disability discrimination or reasonable adjustments. It's just simply a failure to make the provision set out in the HCP as well.
Yeah.
Great. Sorry, I just lost the next question in the chat. Bear with me for a second. The next question, I think, effectively is asking what the role of lawyers might be in terms of dealing with systemic bullying as an issue in a school. Does anybody want to pick that up?
Should I deal with that?
By all means, yeah.
Yeah. So in terms of lawyers dealing with it, it's quite tricky in terms of legal aid. Dealing with complaints and so forth will not be covered. Where there is often a way through, subject obviously to the facts of the case, is because there's an obligation to basically have a anti-bullying policy and to implement it. It's often, they all have them. It's the implementation that's often the problem. And if that is, again, if it's people with particular characteristics who are more likely to be on the receiving end of bullying, if one can then threaten judicial review on that basis, and that invariably gets head teachers to engage with the issue when they weren't doing so before. And I think, as I mentioned previously, I've done numerous letters of that nature when systemic bullying wasn't being addressed, particularly for families of traveller heritage. So there is a way through, but it requires a quite specific set of facts. Most of the time, it will be tricky.
Thanks, Dan. Did anybody else want to add on to that? No? All right. The next question might be slightly fact specific, but we'll see how we get on. It's from Raheel, who essentially is asking about what charities can do potentially about the failure of schools to provide dedicated prayer spaces, and this is particularly in the context of Muslim families finding that schools aren't providing dedicated spaces within their respective schools, and what the scope, at least in principle, there might be to use the public sector equality duty to bring some leverage. Ollie?
Yeah, I can have a go at that. There's an interesting case called Hussein against Secretary of State for the Home Department, which is about a similar issue, but in immigration removal centres, and was a successful challenge partly based on the public sector equality duty, but also substantive grounds of discrimination. And it was a judicial review claim in which our head of chambers, Stephanie Harrison QC, was the lead counsel, and is worth having a read if you want to get some ideas about potential challenges to the lack of prayer spaces, specifically on the issue of prayer space in an immigration removal centre. But yeah, it's going to be very fact specific, but it engages protected characteristics of religion, potentially human rights grounds, Article 9 being the most relevant one, and Article 14, the prohibition on discrimination. But yeah, an interesting question, and one that I think you need to speak to a lawyer about.
Yeah, well, just what one unsurprising 14-year-old client of mine did when the school stopped him praying at school was he just organised the kids and they did so outside. which had the effects eventually of getting the school to engage properly.
Nice. On that point, the next question in the chat is actually asking about how members of the public can access help and support through the project. So what we envisage is basically members of the public contacting one of our partner organisations and asking them to submit a referral. So potentially contacting the Community Empowerment Network, potentially contacting Just for Kids Law, or the law centres who are also supporting the project, and information about that can be found on the website. But essentially, we would hope that referrals would come into the project via those means. So I hope that's helpful. I'm conscious of the time. I'm just going to have a quick scan of anything I might have missed in the Q&A. There is a question about, which is from Amina, which asks, what avenue do you have as a parent if your child has been permanently excluded, but the school doesn't give you any avenue for appeal? Florence, you're still on mute, I think.
Yes, hi. Well, that's totally unlawful anyway, because they should be giving you an avenue. And as I was saying earlier about, if a child is being excluded, they're supposed to be giving you a letter. And at the bottom of that letter, it should actually be giving you your rights to have the opportunity to challenge. It leads to a governing body meeting as well. Obviously, I can't say on all without knowing the full facts of your particular case, but the first point of call is actually getting in contact with the school and letting them know that actually you want to be able to challenge this, and they should be providing you with the information to be able to challenge that. And failing that, just get on to either CEN or JFK or SIP, and we can get in contact with the school for you. But that there is always the right to challenge an exclusion if it's a permanent exclusion. If it's a fixed term exclusion, there are different elements to that. However, you will always have the right to be able to challenge. Does that answer your question? Does that answer the question?
I think it does. Thanks very much, Florence. I think this will be the last question. It's another one for Dan, I think. The question is basically how you can use judicial review to challenge the presence of police in schools. Dan, I think you might have had a case on this theme a little while ago. Perhaps you can share that with us. You're still on mute, though.
Right. Yeah, I've had a couple of cases on this theme. In the case I did in London, effectively a 13-year-old, quite large autistic black child had been rude, I think is the best way of putting it, to his teaching assistants, and landed up at the local magistrates court as a result. The head teacher was of the view that it merited a 3-day suspension, but obviously it got taken further. And what, in terms of trying to challenge the way the police operate, because ultimately, the police do not really want this as the outcome. They don't want to get involved in stuff like this. But the problem is, if you've got the police in schools, they are going to get pulled into things that they shouldn't be, just by the fact that they sort of on tap. We challenged that on a public sector equality duty basis, in respect of, amongst other things, they had no information. There was no oversight of police in schools. They had no information on who was getting caught up and involved with the school police, and so forth. And in that case, police, in fact, fought it. Permission was refused. We got permission on renewal, and then they conceded, and they agreed to effectively keep proper statistics and conduct the equality analysis. And we did something similar in Bristol as well, and a year 7 kid with a mixed race year 7 kid wrongly accused of stealing a cookie from the cookie jar, being given a proper dressing down by a uniformed officer. Told he was lucky not to be taken to the station. So again, public sector equality duty. It was quite hard to think of a way of going at this other than public sector equality duty. But effectively, anything like of similar that happens, the police don't really want that. That is not doesn't improve community relations, and effectively all other forces should be doing the same as these two forces have agreed to do following legal action.
Great. Anybody else want to come in?
It wasn't about that. It was just literally sort of like going back to the school exclusion question, permanent exclusion. It's very, very important to remember that if anybody does have a client or parent that has been excluded, it's permanently excluded, then there's the 15 school days that there should be a governing body hearing. So it's really important to remember that number of days, it has to be heard within 15 school days. So you may need to act quickly depending on when this permanent exclusion has taken place. I think that was for Amina.
Great. Well, it's we're almost at 7 o'clock, which is when we aim to finish. So I think I will draw the event to a close for now. I want to thank each of you again for joining us this evening, and thanks especially to our panelists for their presentations. We look forward to working with you and hearing any ideas, concerns, issues, thoughts that you might have about the project as a whole, any particular initiatives that you think might be useful in working in this area. You know where to find us. So we look forward to seeing you again really soon. Have a good evening.